Hello, everyone. I want to welcome you to today's webinar. My name is Julia Van Buren. I am the Education Trustee for the SILA Foundation. And today we are delighted to present the Background Check Industry Trends Update for 2022 webinar. Presenting again on this topic is Greg Kirsch. Industry recognized expert and background screening solutions in compliance with the Fair Credit Reporting Act. And we are very excited to have him with us today. As chair of the SACS Background Investigations Task Group, Greg and the other committee members have conducted routine and continue to conduct routine surveys to gather data regarding background investigation best practices. Today, Greg will be leading us through the most recent SILA membership survey responses. Keep in mind, we have 1 hour, so questions may be asked in the chat throughout the webinar. Members of the SACS Background Investigations Task Group will be fielding your questions. And then if time permits, at the end, you'll be able to ask additional questions. The PowerPoint presentation that you will be viewing today will be available to active SILA members and will be added as a resource on the SILA website within the next week. The webinar is also being recorded, and it will also be available on the Foundation webinar library within the next week. A link to this recording will be included in the post-webinar survey communication that you will be receiving. I want to thank this month's webinar sponsor, which is Insight Normal Forms. And I want to thank you for your continued support of our mission. It means a lot to us. And without further ado, I'm going to pass it over to Greg. Thank you.
Thanks, Julian. Not if you can hear me. You can still hear me, right? I haven't been muted or anything. I'm going to take that as a yes.
Yes, we can hear you, Greg.
Wonderful. Thank you. So let's get right into the survey here. I'm just trying to get it to advance to the next slide. Some quick background, no pun intended, on the survey itself. It was designed to anonymously gather data from on the background screening practices of the SILA membership that includes insurance carriers, agencies, TPAs, broker dealers, and a couple other entity types. This is actually the fourth iteration of this survey that the task group has done. The original one was in 2016. I think it was very early 2016. We also did one at the tail end of 2017 and then started spacing it out about 2 years. So this is officially the fourth of its kind. It was sent to all member companies except for providers and vendors. Those providers and vendors would be organizations like mine. The total amount of questions was around 30. I say 30-ish because depending on certain yes or no answers, you may get a few more, a few less. I think the total in total count of possible questions someone could have received was about 34. This year around, the total responses were 109. So you do see a decline in the entities that have responded to this survey year over year. But I think you'll see in the data that the percent representation of the type of entities is pretty similar to previous years. And this was officially released to the membership on October 25th and officially closed on December 20th. So another quick item of housekeeping for the survey itself. We have two kind of definitions that are assumed to be implied throughout this survey. A captive employee or exclusive producer is functionally a direct employee of one of the entities. Meanwhile, a broker, independent contractor, or independent or contracted producer is typically someone that could work with one or more than entities and has no direct employment relationship. So a quick spoiler or summary for the survey results. Just in the analysis and going through it, the group and I identified that there were slightly fewer overall respondents in this survey. The respondent demographic mix was very similar to 2019. Some of the charts are almost the exact same. And in most areas, there was little overall movement in practices over the last couple of years. So you'll see that demonstrated. And if you think about it, the last time we did this survey was pre-pandemic. I would assume a lot of organizations didn't spend a lot of time scoping or modifying background screening practices and things just due to other concerns. We did notice that credit report usage continues to decline, and you'll see that in the data. We also noted that employment education verification usage continues to decline within the insurance and securities market. And we noticed the National Criminal Database usage response rate was a little bit less than previous, which we'll dive into that a little bit more when we get to that slide. We introduced some 1033 waiver questions, so we have some new data on that we had never previously collected. And then the overall, the Fair Credit Reporting Act practices and employment permissible purpose awareness is very strong within the SILA membership, which I just know from my past experience and being involved with all these surveys dating back to the first one, that in the beginning it wasn't. I can't say that it was strong. So I think through the task group and through SILA themselves, the association has become a lot more aware of the risks and responded in kind. So the first section, we're going to get right into some of the questions here. The first section, we just have it kind of grouped under the respondent demographics. The very first question is, what type of entity are you that's replying to this survey? On the left here, you see what was responded to in this survey, and you can see in 2019, the pretty much the exact same question. Most categories are functionally the same. Insurance carriers make up the majority of the respondent population. The only thing that was particularly notable was that the carrier and broker dealer population had no representation within this reply. And meanwhile, just a couple of years back, they had replied and they were represented within this population. There was an other question here to specify. These are the responses that were provided by the 5 respondents that had listed other. But generally speaking, if you're going to compare how valid this the data in this slide deck or this survey is compared to previous surveys, it's functionally, although the overall respondent population is a little bit less, the mix is functionally the same. So we'll go to the next question. This was the second of the 2 kind of demographic questions to identify, does your entity conduct background checks? Simple yes or no. The vast majority of the respondent population selected yes, over 90% this year. 2 years back, it was just under 90%. We do ask an exit question of the entities that enter no, and provided some short and some sentence form responses. Some of these things I think could fall into the yes, based off of maybe how they might screen or where they're writing. But overall, from this point on, the respondent population, which you see 109 here, is going to drop, and you'll see a bit of a drop off in responses going forward, because those 5 no's were then, or the 4 no's were then exited from the survey. So let's get into who is being screened and when. So we have, the first thing you're going to see is a series of questions here about specific types of producer population. So does your entity conduct initial background checks on captive / employee / exclusive producers? So these would be for the definitions of this survey, employees that are producers. Here we see just under 60% provided a yes response. In the previous survey, it was a little bit over 60%, but we do have about over 20% that state that they don't have this type of producer, so therefore it's not applicable to their entity. So if you really want to skim this down, the true population of this, out of this 91 that did respond, is right here, and just eyeballing it, you'd say about 75% of the population that has captive or employee type producers are screening them. Meanwhile, the approximate 25% are not performing specific screening searches. So that is the first group, the captive employee exclusive. The next group, same exact question, but built around broker and independent contracted producers. Again, a very large yes response rate, just north of 80, pretty much the exact same kind of grouping as what we saw 2 years ago. The question 5, again, same type question, but this is producers placed through a TPA. Now you'll notice over 50% of the responding population say that the TPA, producers through a TPA, is not something that applies to their entity. So this is really your cross section here of what is relevant as far as who's being screened. So slightly more, if I was gonna assume that combined this is 100%, I'd say this is probably around a 60-40 type split of yes and no as far as whether or not they are performing any type of screening on that TPA population. Next one is producers of a contracted agency or broker dealer, and the data response less. This was the one of the few data points I noticed where there were less not applicable to my entity in the response rate this time around than just a couple of years back. But the overall, the yes and no is pretty, from a ratio perspective, pretty even. So not a lot of change or discuss to warrant a deeper dive there. And then the non-licensed producer support personnel. So this is calling contact center folks and all sorts of other individuals. The graphic is very, very similar to last year, though the only thing of note is a little bit more on the yes. Just a little bit north of 35 on the yes versus right around 35% in a couple of years ago. So, and that there was one other question, kind of a additional layer. So if your entity conducts background checks on a population not listed in this survey, please specify. A lot of different populations were provided this time around. We did, as a task group, try to take into account the number of other responses that were provided in 2019 to see if we needed to incorporate or reframe the question. But overall, I think, from the data points we have, everything's pretty consistent, and some of these populations could get brought into this. Now, something you will see in this question and a couple other questions is around employees. In many cases, some of the additional, more compliance related questions, you'll see in comments that people mention that the screening, particularly of, captive or employee population, is an HR function, and maybe they don't have as much visibility to it. So that's just a little note on these survey results. So let's get into more, now that we know who's responding and who they're running the background screenings on, let's get into the when are you conducting the background check. So generally, when you're conducting the initial background check, which would be the pre-employment or pre-onboarding type of screening, we have a pretty high response rate, 88 respondents in this population. These were the available choices. I listed them out here just because it cuts off in the graph a little bit. But you'll see the vast majority are screening them at the time of onboarding. So this is at the time of contract, appointment, or employment. That is running away with the lead here. It's 55% now. Previous surveys, it was down shy of 50. Another thing that I saw and noted, which would make a tremendous amount of sense, is based off of the type of laws that have been written over the last couple of years around Fair Chance Acts and Ban the Box. At the time of an initial job contract or application, that number has declined, running right around 12%. Meanwhile, in previous surveys, it had been pushing around 18%. So, and from a compliance standpoint, this is wise, running any type of background related service. Just at the time of the initial job contract or application, there hasn't been any type of engagement with that individual, that producer. So typically there's some level of evaluation that takes place, and there's a lot of hurdles that need to be navigated if you're going to screen that early in a process, particularly with an employee population. So, but overall, it's at the time of onboarding or appointment, or followed by at the time of an offer, or what I would consider maybe some type of post offer. A very small respondent population to some other time after the initial application, but prior to onboarding. And we did have a couple others after onboarding. It varies based on states, prior to onboarding, and then more of a detailed breakdown off of different populations. So again, this might be a good benchmark for some of the attendees to compare your current practices with. Now let's go into a question about what about the post-hire or post-onboarding screening, which could be any number of screenings, but functionally after this person has established a relationship with your organization, are you conducting any type of background screening procedures on them? So in this case, do you run ongoing or periodic background checks on existing producers? Could be annual, upon renewal, additional appointment, etc. Any combination of some type of background check that would take place after they've established a relationship with your entity. And pretty much the exact same response ratio as just 2 years ago. So there's been very little change. I personally was expecting a little bit more change to be in this population because of I know we see a lot of with my organization, and we talk about on task group as well, because of Medicare and other requirements, different types of HHS and OIG type ongoing screening or monitoring, things like that. There's growing demand for that. In addition, there's been some expansion of criminal record screening and perhaps driving record screening, but at the end of the day, the data, again, slightly less respondents again from 2 years ago, but as from a percentage point, this is functionally the exact same mix. The next question related to on that same subject was, what is the frequency of your ongoing or periodic background checks? And we gave a lot of different options: annually, every 2 or more years, upon renewal, upon additional appointment or for state of product. At any type of ongoing monitoring, post-incident and or random, so it could be complaint remediation, any one of those scenarios, or just some other scenario overall. And you see, it's just it's a mix all over the place. Oddly enough, compared to at least my personal experience in the industry, ongoing monitoring declined. Last survey was over 10%, and here we're showing 8% response rate on that. The additional appointment population has increased and is now pushing 30%. Meanwhile, the every 2 years or more functionally remains the same as our last survey. Annually is unchanged. Upon renewals increased a little bit. This could just be a byproduct of the mix in respondent population. So again, when we do these surveys, I want to make sure any SILA member organization that is conducting background screening around producers and takes the time out to reply to this, because it is definitely a good way to get your practice to be heard so that we have more unified data. Saw a huge increase in post-incident and or random and complete remediation. So that was notable in its percent jump. And then the other, which has quite a few responses after additional activity after 90 days since the last background investigation, annually, based off of there's new business submission, annually if the state requires it. You can see just the types, the scenarios are based on some type of business rules that don't quite fall into the larger buckets that we have provided. So we might try to break that down a little bit more next time around. So let's go into section 4. What screening products and services are being utilized and how are they being used? This is typically the most, this garners the most attention in all of the survey questions we do. So, and I've devoted 2 slides just to what are the products that people are ordering. So right here in this chart, you have what was submitted this time around and all the products that we've listed out along with an other. And you have exact same comparison with color on 2 years ago. So the things that are completely expected are on the top here: the SSN validation and name and address history, county criminal searches, state criminal searches. I'm still surprised this is as high as it is, just because of state criminal turnaround times. But still, you have your core, criminal history and identity verification services here. Of note, I saw the national multi-jurisdictional database usage drop below 50%, which I was very surprised by that, because I can't remember the last time I was engaged with an insurance entity that was talking about background checks that wasn't going to include a national crim as part of their due diligence package, just because it's such a cost-effective tool inside of a background screening program. You see, it was over 50% last time. I do have a theory that just because criminal history isn't necessarily reported out of the national criminal database, then maybe some of the respondent population is actually having this product used within their background screening, but they don't see a result in the report. They see the corresponding results in a county or a federal crim or a regulatory action product. So just something of note. Credit reports, I mentioned at the top of the slide deck that the usage has declined. Again, if we go back over the last several years, it's been a steady decline. And in fact, one of the questions we see at the very end about information you want covered, somebody does ask about how much are credit reports being used and what value do individuals get out of them. So, this data does speak, this and the next couple slides speak to that. The civil court searches dropped. I'm not surprised. Employment and education verification services dropped in the responding population, which I'm also not surprised. I was expecting a greater decline in employment verifications, but it's not a huge product use item in insurance, at least in my experience. But just based on several factors, some of the employment history provider organizations doubling the pass-through fee price for certain transactions, I fully expected to see some type of a decline there. Regulatory and or those other type actions, which we're going to show this slide again on the next screen, that'll have all these items labeled out with their exact percentage amounts. But we did see a decline there, which is a little bizarre, but it may be just the respondent population. Candidate debit balances, that remains in pretty much status quo from last time. The producer regulatory actions, bankruptcies has a decline. I was a little surprised on the bankruptcies decline, just because in the absence of information that used to be available on credit reports, I would think a drop in credit reports would equal a corresponding increase in the bankruptcy type searches. But overall, it is not there. So perhaps financial data overall there's a story that financial data overall is not as important to the carrier population as it used to be. And then the rest we can jump into. The others are just different roles. A lot of references to FINRA, some individual states where they run credit and financial based off of interpretation of law. So, but if you do want to do a deeper dive just on the current response to this, there's a whole nother slide that you can find in this packet that tells you exactly what the questions were, the response rates by percentage, measure your program against it, and break each of these down so you can see the difference between the regulatory and or prohibited party databases like the OFAC and FINRA versus PDB actions. And just again, I strongly encourage you, as time permits, to review your program and make sure it aligns with the same level of due diligence as your peers. Okay, so the rest of the information will probably move a little bit quicker here. If you run credit reports, what is your overall level of consideration? Do you give the information that's returned? Not a ton of change here, kind of similar charting, little differences here and there, but similar charting to a couple of years ago. Overall, of the parties that are using the credit reports, which is right in here, the moderately impacts leads the way, followed by minimally. Very few seem to be going with substantially. Oddly, I guess some people are just forced to do it because it has no impact on the decision, and yet they're running the product. So, and then in a typical year, what percentage of your candidates are eliminated due in whole or in part to background screening results? So we saw a jump in the less than 1% population. We saw a drop in the 1 to 3% population and a drop in the 3 to 5% population. Oddly enough, the greater than 10% population did increase in its percent of the overall representation. But so that again, with a functionally what can be considered a pre-screened population like insurance producers, where you have to get some type of screening just to have your license, And then there's additional screening requirements placed on the entities that are going to allow them to engage in business. You would expect a generally low rate, but you would expect the things that are eliminating those individuals to be notable in their risk and impact factor. So let's got two quick questions here on 1033 waivers. And the first question was, do you ask about and or collect 1033 waivers from potential producers during the producer onboarding process? Of note is that several replied that it's not applicable to their entity, and then the rest of the remaining responding population is pretty even, all things considered. And that third answer is, I do not know what a 1033 waiver is. So, and just for if I could just touch on that for a brief moment, the 1033 waiver is referencing the Violent Crimes Control and Law Enforcement Act. There's a section 1033 of that act that specifically states that an individual cannot engage in the business of insurance, and I'm paraphrasing here, but cannot engage in the business of insurance if they have felony history of fraud, dishonesty, or breach of trust. So now that is those fraud, dishonesty, and breach of trust categories are treated differently and based on different states, the way the state law is defined. So in some states, a bad check for $200 is a felony, while in other states that's a misdemeanor. So the purpose of the 1033 waiver is if someone has history that may technically fall into one of those categories, they can lobby their state Department of Insurance for a waiver, basically stating, allowing the Department of Insurance to review that history, compare it against the licensing requirements, and then if they think that it does not pose a risk, basically permit that person to be licensed. Other states don't have to honor that 1033 waiver that's issued in one state or the other. And also, as an end user of this, or as a carrier or someone that's working with this producer, you do not technically have to honor that 1033 waiver, though it is very important to at least consider that and ask that question. Now, also of note, it's very possible that some of the responding population here doesn't know about, or is not engaged in any 1033 waiver process within their organization that may take place up front at some licensing validation stage, or may take place in earlier paperwork that maybe isn't within the purview of the person that's responding to this survey. But overall, we've collected this data for the first time, hoping to see this number increase in the future as far as asking about any 1033 waiver for producers. And then the following question, which is directly in line with that, is what level of consideration do you give that waiver if you receive it? And you can see it's the majority of the respondents, again, this population has dropped to just 23 because these are only the people that said yes, that they are asking about it. It moderately impacts their decision, followed by substantially. And this substantially impacts the evaluation is generally, one would assume, is a positive thing to that producer, not an adverse thing to that producer, the way it would impact their evaluation. So let's talk about Fair Credit Reporting Act. For any of you that have attended this, any of the previous webinars on this, we try to ask these some basic questions. We remove some questions that have had very consistent, what I would call acceptable answers over the past several years. But the first question we have here is, do you prescribe to the permissible purpose of employment purposes as defined under the Fair Credit Reporting Act? Vast majority of respondents replied yes, over 90%. A little bit less than 2019, but still the majority of them replied with yes, which is very consistent. You don't have to use that FCRA permissible purpose. There is arguments to others, but based off of my interpretations of most FCRA case law and regulatory guidance around it, that the typical broker or producer falls under the employment permissible purpose. So the next question was, do you provide each candidate with a Fair Credit Reporting Act disclosure and authorization prior to running a background check? The vast majority here say yes. pushing, into the mid to upper 90s on that. And again, I do have to assume that there are some respondents that actually don't know or see the actual paperwork that goes to the producer. They're more responsible for the back end of the program. But the end run here is the end run goal is to make sure that we have 100% on if you're going to run a background check using a third-party organization, you want to make sure that you're providing proper disclosure and obtaining proper written authorization. This question was somewhat new for the survey this year. Does your process include state or local disclosure, ban the box, Fair Chance Act content? For those of you that follow employment law, these are the laws that are designed to ensure that people aren't just immediately eliminating someone based off of the existence of criminal history or checking a box that state that they have criminal history. The largest percent population here is neither. So they are not providing this type of information to employees or producer contractors. Now we do have a lot of statements that this is an HR function. They don't necessarily know, don't necessarily see this stuff, but there is a strong argument that this is an area that we want to look into as an association, and just you should consult with your background screening organization or wherever your forms are being collected and executed with potential candidates and producers. You want to make sure that you're providing certain things and interpreting each one of these state and municipal laws to see whether or not it applies to employees, so it applies to where they live, or to where you're located, or if it applies to contractors. Some of them do call out the term contractors. So, and there's a lot of them. This is not going away. This is something that organizations need to find a way to be compliant with. Do you provide candidates with initial pre-adverse and adverse pre-adverse action notice and or final adverse action notice and a chance to dispute the results? Right around 75% are stating that they do provide this. In previous years, we had asked this as separate questions. So we just tried to group it together here. We definitely, as an association, we want to see this number go up. We want to see it go into the 80s or 90s at least. There's an argument that some of these folks that are doing this are not providing or are not using a consumer reporting agency for their background checks, and a bunch of other factors too. So it's not necessarily a non-compliant population, but it's definitely a risk factor that as an association we want to evaluate. How long are you waiting between the pre-adverse and adverse action? We've seen an increase in the 10-day mark overall, 5, 7, 10. Now I can tell you there's a lot of different laws that have carve-outs. So this is something you'll want to compare your organization's practices with to make sure you're in line. I don't expect to see a lot of greater than 10 business days. Now, we do not send adverse notices. This question actually eliminated the folks that said no on the previous question. So that's why there's no content on this one. But if you look at the rest, this is kind of where the organization sits. And this is where overall I would have expected it to sit. And same with the rest of the task group from our conversations. What method do you use to send them? Keep in mind, last survey was pre-pandemic. This survey is, I can't say it's post-pandemic, but it's post the initial outbreak of the pandemic. So we have a response rate of 55. Saw an increase in email only, completely expected to see that. Still a little surprised at the email mail combination of that's hanging in there that high. Saw a drop in the US mail only, which I would expect. I'm not quite sure why certified overnight mail is still here. I'm not aware of, me personally, specific laws that require it. So it seems like email seems to be the way to go when it comes to engaging with producers on potentially adverse information, making sure they have a copy of the report, all that type of information. Someday we may have to incorporate texting into this, but I don't see that on the horizon anytime soon, just because you're talking about PDF reports and all sorts of other things. What does your adverse action process include state-specific disclosure content? So again, this is a question of, are you providing certain disclosures that states require, not the federal FCRA, but states? A higher response rate on producers, contractors than employees. We do have a population of both, but it's the less than 30% neither population here that I think we would, if you responded with neither, I would encourage you to review your practices and make sure that everybody's on the same page and that you've evaluated whether or not there is a need to or not to do that. Question 25, do you have different content and processes in place? So this was a new question, and it's designed to address some of the requirements that exist in some more recent laws like New York and Illinois. There's also some Los Angeles laws that come into play based off of location, and it's a sequence. So the real word of emphasis here is process. Do you have different content and processes in place to support some of these state-specific pre-averse and adverse action notification requirements? Again, if you're using a background check from a consumer reporting agency, you have to have adverse action processes. If you have adverse action processes, you also have to at least evaluate whether or not these state rules apply based off of where you're onboarding producers and employees. Larger no population than I think anyone would want to see, but I'm also not surprised at all in a candid survey. This is where I would think a lot of organizations, even and a lot of industries, quite frankly, would come into play. Not just the insurance industry, but I think it would be wise to, again, for all SILA members to review their practices, ask their background check organizations about New York and Illinois, determine if you're hiring employees. I could say that I'm pretty confident that the rules apply. If you're hiring or if you're onboarding contracted agents, maybe there's some wiggle room there, but you're going to want to look into those laws specifically and have very specific scenario-based conversation. So very similar line of questioning to wrap this up around the National Insurance Producer Registries producer database. And again, because they are a consumer reporting agency, they're a private entity that collects information, and it's on their website. It's not hidden. They very much acknowledge their role as a consumer reporting agency. So again, all the same stuff applies. Are you using the PDB as part of your process? Vast majority say yes, very similar to last time. Do you provide FCRA disclosure and obtain written authorization? The majority in this case say yes. I would be willing to bet that there's a lot more yeses in this no than what is shown here, just because the disclosure and authorization you provide for a background check would also cover your initial, PDB bumps and things like that too, because it's functionally the same terms. It does not have to be a different document than what you're doing for, your background screening itself. But again, from a graphing standpoint, it's very similar to 2019. Are you providing pre-adverse action? It's some type of initial adverse action if the PDB is used to potentially make an adverse decision. 50-50. We talked about it in the past. That number should be higher. We'd like to see the association increase that number. We have a similar question on adverse action, where if you're taking final adverse action and it's a result of the PDB's data, then there's the FCRA would indicate that you would need to provide a copy of that data and a chance for the individual to dispute it if it was not accurate. So, and decision making, we've asked these questions on the previous surveys as well. What department or entity in your company functionally adjudicates or reviews anything in the background check to determine if you can move forward or not? And in the majority of and these are just the routine transactional ones, the majority is licensing and contracting. It remains the majority. Compliance and legal has roles. HR and recruiting has roles. No response this time around on the committee or team made up of representatives from 2 or more different departments. So while that was present last time, it looks like there's been some consolidation here. So the next question is the same exact question, but it's going to focus on whether or not it's an escalated thing. So a report that has criminal history information in it, or something else. It's basically who reviews the majority of your escalated background check results. The ones where a decision needs to be made, perhaps there's circumstances that need to be pondered. around it, if it's criminal history or credit factors or any other things that could be included. And we saw very, very similar trending this time around. It's a slight decrease on the committee or team response rate, but an increase in the licensing and contracting versus compliance and legal. That seems to be the main shifts in this, but that shift could just be a direct product of who responded this time around versus last time. It may not be organizations that changed their process, but the overall trending here is the same. And finally, does your entity have a defined appeal process for disputed results and decisions? So if you're going to not onboard a producer for any number of reasons, do you have a process in place for them to dispute that decision? The Fair Credit Reporting Act would allow for them to dispute inaccurate information on their background check, but what if they just want to overall challenge your decision and maybe provide some additional circumstances or anything else? That's what this question is designed to address. A greater percent of the population replied with a yes this time than last. So, which also doesn't surprise me given how difficult it is to find talent, particularly in employee populations these days, that if there's a way that you can accept an individual that is otherwise qualified to perform that job, most companies are trying to figure out ways to do that. So that was the end of the core questions. There were 2 questions that were submitted as what we call bonus questions in the survey. Do you have any specific topics that you would like to address during a future conference session or webinar? Please provide them here. A lot of different subjects here. Do others have the Fair Credit Reporting Act signed on an annual, more frequent basis? I think that's an excellent question. And if you're operating in a state like California, I think you absolutely need to ponder having some type of disclosure signed at least annually. Are background checks guidelines published internally or externally? I'm not sure if that's a question for SILA within the organizations, but that's something that I think would definitely, there's a couple talking points that I think may provide value in any of the forums that SILA offers, whether it be in-person conference, webinar, roundtable, panel type scenarios, and any of those things. I think we can bring some of those in. There was a question, I'd love to know if credit is important for insurance companies to run for individual positions such as producers and adjusters. I think the survey did answer that question in a couple of different ways. It seems to be declining in its use. Information on agencies where licensing departments run background checks, or is it part of the process within HR? So we do not ask that question. We don't ask who runs the background check. We've never actually asked that in this survey. We ask who's evaluating it, and we ask what populations it's being run on, but we do not ask which department is actually running the background check. So that may warrant consideration. There's questions about review criteria, industry standards on timing of running, rerunning background checks annually, and then why are some courts taking so long to get information, which actually leads into the very last question, which this came from the SILA forum. We want to hear how carriers are handling the delays in background investigations. So this question was to carriers. How are you handling the delays in background investigations due to the removal of PII, which is person identifiable information, in some states, or delays resulting from general staffing capacity in counties or courts due to the pandemic? So examples of that: Michigan, California, there's been a lot of, whether it's a legislature or litigation, pushing for removal of DOB and other factors. There's been just recently, we received notice that Santa Clara Court in California was now processing any public record clerk searches until January 31st due to their own staffing issues around the pandemic. These kind of things have been an ongoing thing that's being navigated. So the question is, when these delays occur, do you pend your appointment for the completion of that information, or are you running the background investigation post-contracting? So the majority of the respondents, 31, replied with they are pending the appointment for completion of information. A much smaller percentage, 11 respondents, 16%, they are running the background post the contracting appointment when they have a delay scenario. We do have some not applicable, or I've not been affected by this scenario. We have not a carrier, so they wouldn't apply. So really, you're looking at this population, and if I was going to just, use this as my 100%, looks like about 75% of the respondent population is waiting for the information to come back, and 25%, 20, maybe it could be 70-30 here. 30% is appointing anyway and running the background later. And we do have several other responses that I'm not going to go into great detail, just a lot to review. It's all in here, but there are various versions of that information. We wait 20 days, we do this, we do that, we run background and appointment, proceed with a low risk background, assume it's going to be a low risk fail, things like that. So that is the survey. I think I pushed us right up against the clock. Oh, no, we're all right on time. My name is Greg Kirsch. I am the chair of the SILA Agency Carrier Subgroup Background Investigations Task Group. Any SILA members interested in joining our task group, you can. There's no obligation. We are an ongoing task group. Our charter is open, so we don't have any plans on closing down. We conduct a survey every year or every 2 or 3 years. We present some information to the SILA membership. We also update and maintain the background investigations chapter of the SILA Best Practices Handbook. And we meet maybe once every 2 months just to talk about things that are affecting the industry. So sometimes it's just kind of an internal little forum. So if you're interested in joining, please reach out to Diana at dcapes@SILA.org. And I'm going to take a breath and try to look at some of the questions that came in and hand it off to someone from SILA or the SILA Foundation.
Greg.
Julia, quick. I didn't know if you were going to jump in or anyone else. I'm going to hand it off to Julia. So thank you. And I can
It's
go back
okay. No problem. We do have some questions in the chat. If you can go and look at those for just a minute, and I'll send it back over to you. I want to thank you, Greg, and your entire team for pulling all this information together. I know it takes a lot of time and there's a lot of effort that goes into it each year. I also want to thank our webinar sponsor, which is Insight No More Forms. The continued support we receive for our webinars it means a lot to us, because the SILA Foundation brings all these webinars each month to anybody who wants to join at no charge. And so donations, we do take donations, and obviously sponsors of each of our webinars. So if you're interested, please contact the SILA Foundation if you're interested in donating for the 2022 year. And also, just a reminder before I give it back to Greg, if anyone is interested in joining the SACS group or the background check task force, please contact Diana Cates. And Greg, when you're done, I will do my final legal spiel expressing the disclaimer. So do you want to take some questions since we have a few minutes?
Yeah, and I want to make sure I'm looking in the right place, because I have a chat function on here, but is there also another function that I should be looking at in comments? Because I just see a couple, and I'm happy to answer I see one from Wendy. I have a direct message from Carrie. So I just want to, are you seeing other questions that I'm not seeing?
Yes, it's just the chat though. At the very top, Lori Riviera, she asked, why is there a drop in checking employment verifications? And is it better for the employer to run the background reports at the time of onboarding because of the ban the box and state laws?
Both excellent questions. So why is there a drop in employment verifications? Well, I'm not quite sure why there's a drop in employment verifications, but I know the cost to acquire employment verifications has increased significantly due to there's a majority of employers utilize a specific database that basically pays those companies to do that. You may be familiar with. I don't want to name names. I'm just saying there's a specific database to do employment verifications for certain companies, where if you call that company and try to do that employment verification, they will say, we only provide our information through ABC system. So you have to go there to get it, and you pay, and it's $40-something now. So I think, from a pass-through fee, you're getting a lot of the employers are going to these automated systems. The automated systems are charging an increased amount, and you're only getting dates of employment title held. So you're not really getting rehire eligibility and that other stuff. So there's been a conversation in the industry about what is the value of it, but at the same time, most of at least the carriers that I work with, employment verification per se is not part of the background screening package. They're typically concerned about what is the producer's licensing status, what lines of authority do they have history, what's their state availability, what's their criminal history, and some other factors. They may have some other items that they're running on the side, but overall, I just see employment verifications in the insurance vertical has never been a dominant product, but I think it's because of just a number of contractor producers versus captive agents. Your other question, and I see that now. Thank you for pointing that out, Mary Ellen. Is it better for employers to run the background check reports at the time of onboarding because of ban-the-box and state laws? It is advisable, and again, I almost feel like Julia should be reading the disclaimer while I'm talking here, because none of this is legal advice, and I'm not going to be there to help you because I'm not a lawyer. But I can tell you that it is in your best interest to push the background screening as far into the process as possible, and you definitely want it to be post-interview, or post offer, some kind of post. A lot of the state laws specific to whether or not you can ask someone about their criminal history, or whether or not you can make an inquiry into their criminal history through a background check company, are very specific to you have to engage with that person first. You should be evaluating them based off of their character and all the factors, and not just evaluating them solely off of the existence of a criminal history. So yes, it is absolutely advisable, whether you're talking about contractors or employees. It is the belt and suspenders risk aversion model is to run this post offer at the time of contracting, even contingent, just the later in the process, the safer you are. And then looks like we have a couple. Did I state that a disclosure should be signed annually in California? I think I implied that. I think it was inferred. I think California has a specific requirement about background screening in general and consumer reports, where functionally a new disclosure and new authorization process should be obtained prior to running any background check. So while the federal overarching Fair Credit Reporting Act allows for what we call an evergreen disclosure and release, which is they could sign it and throughout the duration of their employment, this is valid, something like that. California is very specific to the fact that a new disclosure and authorization should be obtained each time a consumer report is run. So if you're running a lot of PDB searches, if you're on the same person doing different things like that, and you have a large California population, it's in your best interest to get something signed regarding the California disclosure and authorization requirements, which, by the way, that's an accordion of additional requirements to talk about. But it's in your best interest from a risk aversion standpoint, in my non-legal opinion, to get something signed. As the more frequent that happens, the better off you are. Ideally monthly, if you really wanted to do that, but that would be functionally building something into like where people log in for payroll and acknowledging that once a month or something. But if you're really going to go all out, that's the way to do it. But the letter of the law is prior to a background check being run, prior to each background check being run, something like that. And is there a copy of this presentation available? This was great, and thank you for the information. No, thank you. I didn't make up this information. The membership provided this information. I need to thank the membership for doing this. I just read some graphs and some slides and put some stuff together, but I appreciate it. And yes, a copy of the slide deck and a video recording of the entire webinar, I think, will be available to the SILA membership. I don't see any that, and that was a direct message. I don't have any other direct messages. And Mary Ellen, did I miss anything else that came in?
I think I'm going to go ahead and get
I'm not
the
seeing
legal.
anything.
Yeah.
Greg, Mary Ellen, thank you. I'm going to go ahead and do our legal obligation by
Mhm.
giving the disclosure. Everyone, please remember that the opinions expressed in this webinar are those of the presenter and not necessarily those of the SILA Foundation and webinar sponsor. The presenter and webinar sponsor have been notified of any potential conflicts of interest. Our purpose is to educate and inform. Our webinars do not constitute a legal or professional advice or services. The SILA Foundation nor webinar sponsor can guarantee the accuracy or reliability of the information provided. And attendees need to remember that our webinars are published and stored on various media outlets for an indefinite amount of time. So the content may be outdated, but it's important to do your own research. These are guidelines. These are what we found through the background questionnaires that we received back from our members. So be sure to take what we have as a guide. And of course, if you have any questions, please feel free to reach out to Greg or anyone at SILA. And if you have any additional questions, but I certainly want to thank everyone for joining us. I appreciate, Greg. Thank you so much for your assistance, for putting this, help bringing all this information together and putting it in a format for everybody to understand. It was fantastic, actually. Thank you very much.
My pleasure. And I have to thank the task group. So thank you all.